question about whether, once somebody has tendered their resignation, whether they've lost their cool in the office and just said, I'm leaving, or whether they've actually given a written resignation. Can they legally withdraw it?
Well, in the case of a written resignation, it's very difficult to withdraw once you've put it in writing. Companies have every right to say, you've put it in writing, we've accepted it, we've moved on, you said you wanted to leave on such and such a date, and so that's what we expect. And really, you don't have a strong legal footing in terms of withdrawing that. However, in case of a verbal, of losing your cool in the office, that can also depend on what the contract that says between you and the company. So if the company says that they accept verbal resignations, and it's very clear in the policies and procedures, again, you would have a real issue, particularly if there were witnesses to the verbal resignation. You know, years ago we did a huge amount of business based on a handshake. Today, if there's an issue between an employer and an employee, every person in labour law is going to tell you, is your paperwork in order? Now, that does go two ways though, because in fact what you can do, and some companies have been known to do that, is immediately put in writing that you have resigned in front of witnesses, we are now accepting that verbal resignation and moving on from there. So I would suggest to people, if you don't want to leave the company, don't threaten it. But if you do prefer a verbal resignation, to ensure that if you want to withdraw it, that you do it in the correct process and the company knows what the processes are. My view is, though, that a verbal resignation will often be recognised at the CCMA. We have heard of cases where they have upheld a verbal resignation. Again, as a company, be aware what's in your policies and procedures around that issue.